Well, welcome back to the hot seat. Today, I'm delighted to be joined by a good friend of PCD, Elena Hinchin, at leading London law firm Farrer & Co. Good morning, Elena.
Hi, thanks for having me.
So, for PCD members who've not met you or heard you speak before, Elena, perhaps you could give us a flavour of who you are and the practice that you have at Farrer.
So I'm the immigration partner at Farrer & Co. We have an immigration team which sits within our private client department, although we offer immigration services across the board. We predominantly deal with high net worth individuals, families, but we also provide advice to businesses, educational institutions, and a whole wide variety of clients.
Okay, perfect. Well, today we're just going to chat a little bit about the B word, Brexit. Many of us wish it would have gone away as an issue, but clearly in immigration, there is a very long tail to a lot of the issues that have been thrown up. So we're just going to chat through a variety of topics today linked to that theme, particularly for international high net worth families, which is an area of focus for Farrer & Co. So perhaps we could just kick off, Elena, with the significance of the ending of the transition period. Why is this important for clients?
So, as you say, the transition period has come to an end, and that happened at 11 p.m. on the 31st of December 2020. And the reason that is significant is because that effectively has put an end to EU free movement rights for any European national coming to the UK for the first time or relocating to the UK from that point onward. And so effectively, at the moment, we have two groups of European nationals, very simplistically and broadly speaking, those who were in the UK before the end of the transitional period, and their rights continue as they were, and those who have come or will come to the UK after, and their rights will be on a very different basis.
So it's a real line in the sand, isn't it? And I imagine that part of the difficulty here as well is evidencing that the fact that they were here or not, and because a lot of consequences will flow from that in terms of the rights they can access. So how would you address that as an issue?
Well, precisely, and it's particularly challenging because the government has introduced an additional grace period for the evidential side of things. And so another key date, if you like, is the 30th of June 2021, because up until that point, although European nationals can, if they choose, apply for pre-settled or settled status, they don't have to do that. However, all European nationals who are eligible for this status will have to do that by the 30th of June. And so what we see is that, for example, employers find themselves in a position where they're not quite sure how they can check whether a new employee has the right to work in the UK. And so the way to do that really is to start by asking people whether they have or applied for pre-settled or settled status. Although, again, there is no requirement to do so, so employers can't demand. What we find is that in practice, many European nationals who are eligible have applied for that. And so that could be an easy solution. Equally, just because someone hasn't applied for that status doesn't mean that they can be refused employment on that basis, for example.
And I suppose, do people do this in a self-directed way? So people go out and register by themselves? It's not something that they would take advice around? Or do you find that there is guidance required and uncertainty around it?
So it varies. The application itself is quite a straightforward application. And I think well done on the Home Office for introducing genuinely a simple system. And it's something that's effectively done on one's phone. You download an app, and all you need to show, for example, for pre-settled status application is your identity, which is an electronic passport, and evidence that you started living in the UK before the 31st of December 2020. Easily done. However, as we know, many of our, especially very globally mobile clients, have different circumstances which don't quite neatly fit any specific box. And so, yes, we have been given a lot of advice around that.
Okay, very interesting. I mean, one of the main areas in which high net worth clients look at coming to the UK is around education. And there's a lot of implications for people wanting to have children educated in the UK. How are you seeing that? How are you seeing implications of these changes affecting how people are looking at putting children through the education system here in the UK?
And so this is really interesting because what we saw in the year in the run up to the end of the transitional period is quite a few third country nationals, i.e. non-European and non-British or Irish, applying for various European schemes such as Malta or Cyprus. And that was with a view to making sure that their very young children, sometimes babies, will acquire European nationality in time before the end of the transitional period, so that in the future they can utilize the UK education system without having to apply for a student visa. Because, as I said, any European national who was in the UK before the end of the transitional period will be able to study as a European national has in the past, so very much freely. Anyone who wants to bring their child to be educated in the UK now will have to go down the sponsorship route, which limits the schools, because not all schools are able to offer sponsored visas, and B, what we hear, although we have a different department dealing with this and we'll need to defer to them, is that it might have an impact on fees.
And for adult children looking at university options in the UK, has anything changed significantly there? Are the visa options that they're able to access as they were?
So that actually has become better. And so what the government has done is they have accepted that Brexit will effectively restrict accessibility to workforce accessibility. And so what they have done is they've opened a few new routes and changed some of the existing routes. And so one of the new routes, which will come into force this summer, is the graduate visa. And so anyone who graduates from university in the UK, and you have very specific dates around it, will qualify for a visa which will allow them to continue working in the UK without sponsorship at the very first instance. And that becomes, as you say, really quite important. For example, for European nationals who start studying in the UK and move here, let's say now or any time from January 2021 onwards.
Is it still common for the children of wealthy families to look at an investor visa route option combined with studying higher education in the UK? Is that something that people still utilize where they have the option?
Very interesting. So yes, and we see, depending on the regions, geographic regions, we see slightly different trends. The broad answer is yes, parents do try and ensure that children, adult or younger, who come to the UK to be educated, utilize this time so that it counts towards a residency visa and ultimately permanent residence and citizenship. How that's done? Yes, often it's done by way of the parents gifting the child £2 million for an investor visa. Some region, for example, the Far East, they used to favor the entrepreneur route, for example, and so combine work and studies in this manner sometimes as well.
Okay, thank you. I mean, you touched on families using passports and visas from other jurisdictions like Malta, Portugal, or Cyprus, European-wide schemes. Obviously, with Brexit, there's a reassessment needs to be made of how those individuals can use those documents and what the impact is for the UK. How do you see that unfolding?
And so we had a few clients who came to us probably, I would say, in about October, November time. So very briefly before the free movement rights ended, and said, look, our passports, our applications are in the queue, but we won't have our passports in time before the end of the transitional period. What does that mean for us? And the answer is that it's very much divided into two. If for people who qualified for citizenship, who obtained Maltese or Cypriot citizenship, for example, before the 31st of December, they are absolutely fine. They're European nationals before the end of the transitional period. Those who haven't obtained citizenship won't unfortunately qualify under that and will be subject to the new generic immigration system. And just coming back to the previous point, there is a bit of a confusion amongst clients sometimes, because they seem to think that unless you have a passport, you don't have citizenship, and that's not the case. Passports are evidence of your citizenship. So just because some clients don't have passports doesn't necessarily mean they're not citizens or have not become citizens in time.
Well, very interesting. Looks like a point that needs to be urgently reviewed if they're relying on that to stay in the UK. So that's very interesting. And just looking at more broadly, high net worth clients often come to the UK, establish a family office or enterprise. That requires them to bring in staff. I mean, how do you see the immigration system for the high net worth client who is coming from perhaps outside Europe, who wants to bring people to populate his business office that he trusts and relies on? What are the options that those kind of clients have?
So unfortunately, the B word is relevant here as well, because many of our clients used to use, for example, domestic staff who had European nationalities and therefore never needed visas in the UK. And of course, those people had absolute flexibility as to mobility. And so clients now find themselves in a position of saying, look, I visit the UK 3-4 months a year. I always used to bring my, I don't know, Russian driver with me. What do I do now? And again, the answer will vary depending on how long and when those domestic workers, for example, spend time in the UK before the end of the transitional period. And in fact, we had clients where their employees could apply for pre-settled or settled status. So that was very helpful. And that's important to be aware of, because people don't necessarily think of that option. But also where that's not possible, it's worth just looking at other options. So for example, we have some clients whose domestic workers have actually gone on to study in the UK. And so they have a sponsored visa. And that sometimes allows them to work on a part-time basis for their previous employers during term time or even full-time basis during kind of university or school holidays. Also, the Home Office has lowered the threshold for a skilled worker. And so non-European national workers used to be able to come to the UK under a sponsored route if they had the equivalent of a university degree in experience or in qualifications. Now that has been lowered, again, to kind of address the Brexit-related issues, that has been lowered to a school leaver level. And so many more people will now qualify under the skill route than in the past.
So it might be easier to bring in your CFO or your staff for your office, but more difficult for your driver, as you say, or your nanny.
Correct. Although it's always worth looking at options.
Absolutely, absolutely. And obviously, the last 12 months have been hugely affected in terms of travel. The global high net worth client is used to traveling throughout the world all year long, and travel bans have affected the movement of individuals, and this obviously has implications for people perhaps outstaying visas that they have. How are you seeing that filtering through in terms of people who've been stuck in the UK, outstaying visas, perhaps in breach of some of the terms? What are you seeing on the compliance of that?
So we certainly, so it's really divided. The first category is the category you mentioned, people who effectively got stuck in the UK because of COVID. And then I will also look at people who got stuck outside the UK because of COVID. So for people who got stuck in the UK and who may have overstayed the validity of their visas or the terms of their visas, the position is very much, there is a specific guidance the Home Office has issued, and they keep revising it on an ongoing basis. So it's worth making sure that whoever advises looks at that at the relevant time. The Home Office position is generally that they accept that there were certain periods in the last year where people were unable to leave the UK. And so but what they want to see is that people took all reasonable steps to leave. And if they were unable, then they either regularized their status or applied for something called exceptional assurance, which is a bit of a hybrid temporary measure the Home Office put in place. And the idea behind it, it's not derived from any legislation. So it's a bit of an odd one for immigration lawyers. But the idea behind it is people who apply for this and receive this status will be protected from any adverse implications for future visa applications. And that's quite important because usually overstayers have significant issues with future visa applications. So that's for people who got stuck in the UK. People who got stuck outside the UK face problems with, for example, applications for indefinite leave to remain or citizenship, because they don't all of a sudden meet the necessary day count requirement in the UK. And so the Home Office's position on that is not yet very clear, and they have issued slightly different guidance for different visa categories. Our experience so far has been that, again, if we can show that people have done all they can to come back to the UK and minimize their days outside of the UK, then the Home Office is amenable to that. I have heard from other immigration advisors that they had some less positive experiences with the Home Office. And so it's just something to be aware of. But I always warn clients not to treat it as a get out of jail free card. Because we do see clients or did see clients who said, well, hold on, it's COVID. And so I don't want to be stuck in the UK. And that's not really a reason for the Home Office.
No, absolutely. But yeah, I can see the latter of those two issues as a real thorny one. So thank you for laying that out so clearly. Well, Elena, thank you for talking to me today. Look forward to featuring you next week on our Global Mobility webinar, where we're going to be discussing high net worth clients moving to the UK. And we look forward to sharing this discussion with our members.
Thank you very much. Thank you for having me.